So for our roundtable discussion on the 16th of September, we got together individuals working on these various different types of discrimination, and all of these minds could come together and sort of exchange with each other what they had learned from their separate fields while working on this same subject, to try and tease out that underlying thread of what is discrimination in India.
There are many issues at the center of which is the right against discrimination, many compelling issues which have caused severe anxieties to people, to both constitutional lawyers, to academics and to lawyers in general. But for every positive development like Navteej Jauhar, there are several others which cause a lot of anxiety, a lot of worries to all of us who still care about the right against discrimination. For instance, only recently, in November last year, the Supreme Court validated the Constitution Amendment which provided for reservations to economically weaker sections. Now the catch here is that this particular amendment only provided reservations to classes of persons other than those backward classes which are already receiving reservations. And that's where a cause of worry arises. There are several other such issues which worry us a lot. For instance, the issue of marital rape. As we know, criminal law in India does not penalize a man for sexual assault of his own wife. Marital status of a woman, the fact of her being married, precludes her from initiating prosecution against a man who sexually assaulted her, and in this case, the man happens to be her husband. This is not just a list of prominent and emotive issues, but it is also indicative of an underlying problem on the way in which we should think about the right against discrimination in India. What ties all of these issues together is the fact that no person should be discriminated against on grounds of their religion, on grounds of their sex, on grounds of their caste, on any other ground that sets them apart from any other person.
To just use like a metaphor, imagine you were constantly tripping over yourself or stumbling while you're walking around, and you're having this problem over and over again. You'd start thinking that maybe maybe your eyesight is weak, or you're suffering from fatigue or something like that. Similarly, we felt that India was also stumbling over itself in its social, in its political life over and over again. People were researching on sex discrimination, people were researching on religious discrimination and religious governance, on secularism, on personal laws, or otherwise there were people working on caste and reservations, but we didn't get the sense that people were talking to each other. What did they all agree on when it came to this question? So this was somewhat where we were coming from when we thought of starting out on this report. Judges, it's not just individuals, but even judges don't seem to agree on each other. There isn't judicial consensus on what the right against discrimination means. What is the test that a judge should apply when testing whether or not a government measure is actually discriminatory. And you can see these in cases like the EWS case and the hijab case. Judges are disagreeing with each other. And our finding in our research was that indeed discrimination law in India needed this consensus. It needed some common basis or principle that people could agree upon when it comes at least to the basics of that right. What mattered more was what choice the government had made about what it wanted to achieve rather than the effects on individual lives. The law has been advancing in other countries to try and capture such situations where, you know, somebody's intention may not be as clearly written in the law itself, but you can tell from various facts whether they might have a discriminatory intention, or even if there's no possibility of finding that intention, whether or not the effects are so discriminatory, whether the effects of that measure harm somebody. What does the Right Against Discrimination have to say about affirmative action, about reservations? And finally, many of the most urgent questions perhaps that have been coming up in the last few years are about when individuals discriminate against each other, which is to say private discrimination. And lastly, our constitution is silent on some questions. Discrimination against people who are not referred to in our constitution. For example, discrimination on the grounds of disability, on the grounds of sexual orientation, on the grounds of gender identity, nationality. All of these sorts of questions have been coming up in recent cases and have always been questions that people have had to deal with. There must be something that we can agree upon that is part of our founding document.